All right. Well, good morning, everyone. Welcome to the Elder Law Training Series presented by Pro Seniors and the Ohio Department of Aging in collaboration with the Ohio Training Advisory Committee. We've had, over the course of the year, many excellent sessions on elder law topics. We have the recordings and materials for those past sessions in a shared online folder. I will put the link to that folder in the chat in just a few moments. After opening that link, you'll also find the folder for today, the Veterans Benefit session. And inside that folder, you can find the PDF of the PowerPoint presentation if you would like to follow along with the presenter today. We will have one more training in this series next Friday. Miriam Sheeline will be back to present on reverse mortgages. So we'll also make sure we share with you that link to register in case you haven't done so already. A few logistics before we get started. Today's session, of course, will be recorded and also posted in that folder that I will share with you in a few moments. There will be polling questions during the presentation today. If you're an attorney requesting CLE credit, you need to respond to those polling questions. If you have trouble responding in the pop-up polling box, feel free to put your responses in the chat and we will be able to capture it that way as well. At the end of the session today, there will also be a survey that will pop up on your screen. Again, if you're an attorney seeking CLE credit, you will need to respond to that survey. If you miss the survey pop-up for whatever reason, we will make sure the link to it is in the follow-up email that will get sent early next week. And finally, if you have questions today during the presentation, feel free to use the Q&A box in your Zoom. We'll be monitoring that as we go. And our presenter will stop at various points in his presentation and we'll let him know if you have questions for him. So now turning to today's session, we are pleased to have with us attorney Matthew Barnes. He is a staff attorney with Pro Seniors, where he's been since 2013, specializing in a range of public benefits, veterans benefits, and other elder law issues. So take it away, Matt.
Good morning, everyone. Happy Friday. Today, we're going to be covering two VA cash benefits, the Service-Connected Disability Compensation Program and the Non-Service-Connected Disability Pension Program. Just covering the basics of what these programs are, what the eligibility requirements are as well. And as Melissa was saying, you can just add questions as we go. I'll be trying to check on them, usually after poll questions. Just an overview of Pro Seniors' mission for those of you who might not be probably familiar with us. We are a legal nonprofit located in Cincinnati, and our mission is to enhance the independence and quality of life for older adults by empowering them, protecting their interests, and facilitating their access to resources. I'll be talking about our legal helpline services we do. We do have in-house staff attorneys, which I am one of, and the kind of work that we usually do is elder law focused, especially for low income and low resource individuals. So that is a lot of public benefits issues that I deal with. Things like long-term care Medicaid, Medicare, Social Security benefits, VA benefits, some housing and consumer issues. Those are our focus. And as the share of the population of older adults increases, this mission becomes ever more important. One of our services we provide, probably what we're most known for, is we do have a statewide legal helpline. And to qualify for that, anybody who's age 60 and older and Ohio resident can call the helpline, or somebody can call on their behalf. So a contact person can call in on their behalf to that number, and they talk for 30 minutes for free with a helpline attorney. It's not like a one-time thing. They can set up new appointments as well to either follow up on the same issue or if they have a new issue. They also can get referrals. We have a private in-house referral attorney panel. We can get referrals to private attorneys as well. And that is statewide. So anybody throughout the state, even though we're in Cincinnati. We also have a pension rights project, and this is actually for people of any age in Ohio, but it's about retirement pensions. and we're going to be talking about VA pensions, so I don't want to confuse that today. It's not about VA pensions, about retirement pensions. Anybody who has any kind of questions about those, where they think they qualify, I have lost access, do they still qualify for a pension? They can call that number as well. And it's in multiple states besides just Ohio. It's Indiana, Kentucky, Michigan, Pennsylvania, and Tennessee. They also are able to help people. So we also have the Ohio Senior Medicare Patrol in our office, who has volunteers that help educate about Medicare fraud and scams. And so anybody who has concerns about Medicare fraud, they think that something happened to them, they can call that number to see if they can help. Or if they're not sure if a Medicare product is real that they're being offered, that's also gonna be a good place to start. We do also try to focus on veterans specifically. Right now, I am the attorney that focuses on veterans issues, and all of my clients that I get right now in-house are veterans. And right now, we are having a monthly legal clinic with the Cincinnati VA Medical Center in collaboration with the Legal Aid of Cincinnati. I also help host the Veterans Affinity Group, where we meet every other month to discuss veterans issues, possible advocacy, and outreach ideas to other veteran service organizations. Some of the members of that affinity group were able to help us actually do outreach and advocacy regarding a Ohio Veterans Home policy that was making it tougher for certain veterans with cognitive disabilities to have access. And that advocacy, we were able to get that policy changed. It was great. That was just this past spring. So in terms of the kind of work I do specifically, again, it's mostly public benefits related. I'm going to be going over these two types of veterans benefits. I don't really handle these types of claims like applications for pension benefits or compensation claims. The work I do, it's pretty limited in terms of VA benefits. I mainly work with overpayment issues related, especially usually to pension. But I am accredited with the VA because you have to be even to work on that kind of on those kind of issues. I am accredited with the VA to work on veterans benefits claims. And most of my other focus though are on other types of public benefits, like long-term care, Medicaid, Medicare, Social Security. But I do find having this knowledge and this background of VA benefits is very helpful because of the way it interacts with other public benefits. It's good to know the basics and help clients understand all of their options. ProSeniors also does host the region's long-term care ombudsman program, and just something you guys should be aware of. I mean, this is, I know, a statewide presentation, so our long-term care ombudsman office isn't going to be necessarily yours, but every region has one. So to locate your local one, you just would call that number. But just a great resource out there for anybody who's in a long-term care situation, because a long-term care ombudsman, they're essentially third-party advocates for people who are in those nursing homes, in those assisted living facilities, and they're there to help educate those residents about their rights, to help them speak up for their care, to make sure that the quality of life issues are being addressed. Because in a lot of instances where somebody's in a long-term care facility, they may not have, sometimes don't have any family or friends to help look out for them. And that's where the ombudsman can really come in to help. If they do, the ombudsman can always help, but can really make sure that there's somebody there that's advocating for them and making sure that their rights are being protected. We also do have a website, which I always like to point out this specific area just because of the public benefits I do. But lots of great tools there for some of the work that you guys might do, especially if you're involved in public benefits. We have this Medicare, Medicaid eligibility dropdown that gives all the current numbers on Medicare and Medicaid because they change all the time when it comes to eligibility purposes. We also have a fact sheets page that you can click on and look at all the different fact sheets that we have as well. All right, so now getting to the meat of what we're going to be covering today: veterans benefits, service-connected disability compensation, and the non-service connected disability pension program. What we're going to be trying to do today is understand, first of all, if you do want to get involved and actually help clients with this rather than just giving them information, we want to understand what the VA accreditation requirements are so you can actually help with VA benefits. And then understand what the basic eligibility requirements are that a veteran would have to meet before they can qualify for either the compensation program or the pension program. Understand that as well. And then understand the basic eligibility for both compensation and pension. And through all of that, hopefully you'll also understand what the differences are between the pension and compensation program. It's definitely, if you're not very familiar with VA benefits, the terminology is kind of like gobbledygook. It makes it sound like you're not quite sure what is what. Definitely clients that I assist, they don't always really understand the differences either. And so just helping them understand what's going on, what their options are, what kind of benefits they're getting can be very helpful too. And just as a quick overview of the differences between the compensation and pension program, before we get into some of the specifics, it's just kind of nice to have this overview up front. The service-connected compensation program, it's a monthly benefit for veterans that have a current disability linked to something that happened while they were in service. And it's not means tested. So the purpose and policy behind compensation benefits, and it's kind of in the name, it says service connected. That's why it says that, because it's a current disability that happened because of something in service. And it's compensation, meaning they're just compensating the veteran for their service. They have a current disability that causes issues. We're going to give you money to compensate for that service, that disability that was caused by that service-connected disability. So it doesn't matter how much the veteran has in terms of income and resources, not an issue. They're just going to get the money. And that's the point of that program. Versus the non-service connected pension program. Again, it's in the name. It kind of makes sense when you see the names. It is somebody who's disabled, permanently and totally disabled, or age 65 plus. That's presumed to be disabled for this purpose. And it's a monthly benefit for low income wartime veterans, also have low net worth. And it is means tested. And the point of this program is just to keep veterans out of poverty. It's very similar to the SSI program and what it's trying to do. So it's a whole different purpose that it has. And that's why it is means tested. And so the rules are different, very different. And it could be that somebody qualifies for both the compensation program and the pension program. Just be aware, can't receive both at the same time. Usually they're just going to automatically give whichever one gives the most. Technically, the veteran can choose, but it's going to be whichever one's currently giving them the most, that's the one they're going to receive. Just to give an overview of how much is spent on these programs and how many people are receiving them. For the Service-Connected Disability Compensation Program, the number of veteran recipients for the fiscal year 2023 was 5.6 million with 133.09 billion expenditure. And you can see that's a lot more. It's a lot more recipients and it's a lot more expenditure than the non-service connected pension. Only 153,000 veteran recipients, 2.18 billion received. And compensation benefits are the big cash benefit when it comes to the VA program. And that's kind of what the VA is known for. It's kind of their bread and butter. It's a very popular program. People really like the idea of compensating veterans who are currently disabled because it's something that happened in service. So that is kind of like what the VA is known for. And those benefits can be very significant. The monthly amount of the benefits compared to the pension program, when we look at the rates, the monthly benefit rates, the compensation rates can be much higher. And that's also why you see those expenditures being so high. And so it might seem like the non-service connected pension is like this tiny program, who really cares about it? Or is it really that, is it really going to be that relevant? And generally, at least for the population we work with, which are lower income, lower resource clients, it is a significant benefit. A lot of them do potentially qualify for this benefit. So even though overall, not a lot of veterans get this compared to compensation, for the type of work we do with lower income, lower resource individuals, it could be that a lot more of them will qualify for this type of benefit. All right, so if you're an attorney who wants to get involved in VA benefits work, you do have to become accredited. It's for the sole purpose of preparing, presenting, and prosecuting claims before the VA. FAQs on the attorney accreditation website says that even if you're advising on benefit claims without filing applications, you need to be accredited. And it's not too hard of a process. It's pretty straightforward. And once accredited, an attorney can begin representing clients on VA benefit claims. And all you really got to do to start the process is submit a VA Form 21A. And sometimes, depending on what's on that form, they might ask you further documentation as well. But you submit that to the VA Office of General Counsel, and all the information is on there. It is very straightforward. Once you do that, to maintain accreditation, you do have to complete 3 hours of approved CLE credits within 1 year of the date of initial accreditation. So, it has to be approved for VA accreditation purposes specifically. I find these are pretty easy to find usually. I use the Practicing Law Institute a lot with our legal nonprofit, and there's always VA accreditation 3-hour CLEs on there for me to view to continue to do this, because after that initial 3-hour of CLE within 1 year of the date of initial accreditation, you do have to continue doing this. You have to complete an additional 3 hours no later than 3 years from the date of your accreditation, and every 2 years thereafter. So essentially, after that first year, every 2 years after, you want to make sure that you always have to submit that you've been taking these CLEs, these accredited CLEs, and submit them to the Office of General Counsel. And all you do is email it to them. It's pretty straightforward there. You do also have to submit an annual certification of good standing for anywhere that you're practicing and admitted to practice every year. So that's the other requirement. Again, you just submit it to the email inbox. It can seem like when I was initially accredited, I just started submitting stuff to that email. I never got any responses. So always, there is a website where you can check. Does it still show that I'm accredited? Because you can search for accredited attorneys. Because I'd ask questions sometimes like, "Did you get this?" They don't usually always respond, but one thing you can do is ask when you're initially accredited what the specific date was you were accredited, because they don't really tell you that either. And that way you can put in your calendar going forward, like, this is every 2 years or every year. Here's the date I need to submit my certificate of good standing. All right, and that brings us to our first poll question. I'll put it all the way up here. After completing initial VA accreditation requirements and becoming accredited, an attorney does not need to complete further CLE training to maintain accreditation. Is that true or false?
Give about 10 more seconds and I'll shut the poll down. Okay.
All right, yeah, false. It is definitely false. You have to continue every other 2 years, essentially. First 3 years of your initial accreditation, plus you've already done that initial year of CLE training, and every 2 years thereafter, you got to do that specific VA accredited approved accreditation training. And the type of training that is, it's usually going to be covering what we're covering today to some degree, but even more in depth in some ways. And it also will usually cover the VA claims process and appeals. It might cover discharge upgrades and some other things as well, but usually it's just kind of reorienting you to that. So it's usually the same kind of topics over and over, but good to keep up on those. And I can look to see if there's any questions real fast. And none yet, so I'll keep going. So before we get into the eligibility requirements, just because I'll be referencing some of these laws and the regulations and statutes, the basic law governing VA benefits, you'll find that it's Title 38 of the USC and the CFR. When it comes to case law, you look at the Federal Circuit, the Court of Appeals for Veterans Claims, and Board of Veterans Appeals. Those are not presidential, but they can be helpful to review. And there's also VA policy that you can find at the M21-1 benefits adjudication manual, which is super helpful. A lot of when you're submitting, veterans are submitting claims. I mean, the VA workers who are looking at their claims and seeing if they're going to be eligible, this is the manual that they use. It's not like official necessarily, but it's great because it goes into a great level of detail and at least helps understand why the VA is doing what they're doing. It can really shed a lot of light on that. And generally, the regulations, as is usually the case, are also just more detailed when you're trying to figure out more specifics regarding a situation. The M21-1 manual, I guess it's kind of similar for people who do with Social Security to the POMS, the Personnel Operations Manual System. Again, it's like the things the workers use, and it's all available online and fairly easy to search, actually. And then the VA Office of General Counsel also has some precedent opinions as well. In terms of resources, some good resources for anybody who wants to get into helping with veterans benefits. The Veterans Benefits Manual is great. I use that all the time. It's updated annually. You can find it in the LexisNexis store. Even, especially if you're starting out, but even now that I've been doing this for about 5 years, where I've really been looking at VA benefits stuff, just helping you find exactly where in the statutes and regulations all of the relevant rules are, and they do help give some good commentary on best practices as well. And there is also the National Organization of Veterans Advocates. That's another resource. All right, so getting to eligibility for these two programs, for the compensation program and the pension program, the first step is we have to find out who is eligible for VA benefits, including the compensation and pension program. There's basic eligibility requirements of who is considered a veteran that have to be met first. And then after that, it's determining specifically for compensation benefits and non-service connected pension, what are the additional criteria that they would need to qualify for benefits. So for that first step, who has veteran status according to the VA? Well, this is the definition of a veteran. It's a person who served in the active military, naval, air, or space service, and who is discharged or released therefrom under conditions other than dishonorable. That means, what does active military mean? It means active duty in the Army, Navy, Marine Corps, Air Force, Space Force, or Coast Guard. That counts. If you're in the reserves, it means only when you're on active duty. And if you're in the National Guard, it means only active duty stemming from federal service, because National Guard might just be called up for state service, and that isn't going to count. So there are lots of possible nuances and exceptions when it comes to this as well, especially for like very specific roles that aren't in the Army, Navy, or any of those forces. It can get kind of very specific as to who would qualify. So one great resource if a veteran isn't quite sure what to do, and a great resource in general, is the local county Veteran Service Commission in terms of being a free resource. If there's not anybody else that can help with the whole claims process, they can help the veteran figure out basic stuff like this, like, do I have veteran status? Each county in Ohio has a Veteran Service Commission, and these are under the Ohio Department of Veteran Services. They're staffed by veterans, and the main thing that these Veteran Service Commissions do is help veterans navigate VA benefits, and they do it for free. So it's a great starting resource, and especially for like basic stuff like this, which can be pretty complicated, especially if you're not really familiar with all the military lingo, whether somebody's going to actually qualify as a veteran, were they active duty or not during certain time periods. The Veteran Service Commissions can be helpful in just getting that basic information together. And one of the, again, just for like finding out when somebody might have had active duty, one of the beneficial forms to get a veteran can get is their discharge, certificate of release or discharge from active duty. Usually that's going to be the DD-214. It's not always. It depends if they're in the National Guard. It'll probably be a different kind of form. But it's a very helpful form to get basic information regarding their veteran status, of whether they're going to be able to qualify for other types of VA benefits, because it does talk about the dates of service. It also talks about, which we'll get into more later, their character of service, which does impact whether or not a veteran can qualify for certain types of VA benefits. And this is the Armed Forces characterization of service that we'll get back to. To get the DD-214, again, they can go, if they don't have it themselves, they can go to the local county Veteran Service Commission. They can help with that. It is possible to request it online. It's a pretty straightforward process as well. But it can be helpful to have that, just to determine what's going on, what kind of benefits are they possibly going to be eligible for when it comes to VA benefits. And that other requirement besides active duty is that their service has to be other than dishonorable. Now, this is not the same as the Armed Forces characterization of service that I was just looking at that discharge form with you guys at. That's a whole different thing. They do interact with each other because for VA benefits purposes, whether somebody has other than dishonorable service does depend on that characterization of service to some degree. But it is its own separate process. The VA, for VA benefits purposes, they have a separate process determining, are they going to qualify for benefits? The characterization of service impacts it, but it's not like it lines up one for one, as we'll discuss. And just keep in mind, generally the purpose of the VA benefits programs are to help veterans. And one thing to keep in mind, and with these different policies that the VA has, is anybody who has a negative characterization of service for their time in the armed forces, I mean, generally the statistics show they have worse outcomes in life. And so they're usually the people who need these VA benefits the most, but it might keep them from getting these VA benefits. But it is that's part of the reason why it's a different process for determining whether somebody's service was other than dishonorable for VA benefits purposes, because it's a different program. It's a different, they're going for a different goal than maybe what the Armed Forces characterization of service is going for. So for VA benefits purposes, you're either dishonorable or other than dishonorable to determine if you qualify for VA benefits. It's those two buckets only. The Armed Forces characterization of service, as we'll go over, there's 6 different types, and there's some other weird ones, but and I'll kind of show you how they look. So how does the VA determine whether you fit in one of these two buckets for benefits purposes? They are going to look to see, are there any statutory bars to the VA benefits present? And are there any regulatory bars to VA benefits present? If there are, no benefits. If there aren't, benefits. Pretty straightforward, it seems. But that process is called a character of discharge determination. And it's not always needed. A lot of times if somebody does have an honorable service as their Armed Forces characterization of service, they're not going to need to have a character of discharge determination. They're assumed they're going to qualify for VA benefits. But in a lot of other instances, they might need to review more in depth the veteran's record to see if one of these statutory bars or regulatory bars apply. So what are the statutory bars? There are 6 of them. There is an exception for insanity for these, so just keep that in mind. But if you're sentenced to a general court-martial, if you're a conscientious objector, if you're a deserter, resignation as an officer for good of the service, or if you're an alien during period of hostilities, if it's affirmatively shown, the individual requests release, these are statutory bars. These ones are the fairly straightforward ones, relatively speaking. And the 6th one is absent without official leave. If you're AWOL for a continuous period of 180 days, then you're barred. Except, and this one's different from the other 5, you can demonstrate compelling circumstances for that reason for being absent. If you can demonstrate the compelling circumstances, then you can still qualify for benefits. So at least with this 6th statutory bar, there's, the veteran can make an argument, and there's a lot of factors they consider. We're going to go over what they are. Keep in mind, this compelling circumstances exception that we're going to be going over, it also applies to 2 regulatory bars that we're going to discuss. It applies to the moral turpitude bar and the willful and persistent misconduct bar as well. The compelling circumstances can be argued for those 2 bars as well. And that's why you'll see, because this is directly from the regulation regarding what detailing what compelling circumstances are, you'll see they're talking about AWOL or misconduct. And that's because it now applies to, relatively newly applies to 2 regulatory bars as well. So the first thing they're going to look at for compelling circumstances, somebody with an AWOL issue, is was their service outside of when they were gone meritorious? Was it honest? Was it faithful? Did they have honorable service all the rest of the time? That's a factor for them to consider. They also will consider mental or cognitive impairments at the time. And they list very specific diagnoses, but it's not all inclusive. This is a relatively new change that they are being more detailed with the mental or cognitive impairments. Definitely for older veterans, it can be that these mental or cognitive impairments were not recognized as such at the time. And so the problem for them might be trying to find, when they're arguing compelling circumstances, trying to find information from back then showing, hey, these were something I was going through. But it is something they can ask, they can argue. It looks at their physical health, combat-related or overseas-related hardship. Did they go through sexual abuse or assault? Was there duress, coercion, or desperation? Do they have family obligations or compare obligations to third parties? Do they have, look at their age, look at their education, their cultural background, judgmental maturity? So this is nice that they have kind of expand these factors and been more specific as to, they really want the claims worker to be all inclusive and to try to look at what's going on, the whole situation, which is good. For family obligations, maybe you had somebody who was serving overseas and their family got in a car wreck, their spouse and kids are injured, and they feel like they have to go take care of them. I mean, something that could be argued, so there's lots of circumstances that can be argued, which can make it more likely for a veteran to actually still qualify for these benefits. And finally, the last factor is whether a valid offense would have precluded a conviction for AWOL misconduct under the Uniform Code of Military Justice. And then we'll get into the regulatory bars. These were recently updated, June 25th of 2024, so pretty recently. I was actually on the task force way back in 2020 that helped to submit comments on the proposed changes. At that time, what we were asking for, the main thing we were asking for is that we wanted them to do away with the regulatory bars completely, because they aren't necessary. They already have the statutory bars. Don't need the regulatory bars. Plus, the regulatory bars some of them are very arbitrary. They can be interpreted in lots of ways, and so it seemed like depending on the claims worker you get, they could read it one way or the other, and so you're probably gonna get a lot of inconsistent decisions. And they've tried to remedy all that. They did keep the regulatory bars. They didn't do away with those. One of the things in our comments that you're trying to do is, if they were going to keep them, you need to be more specific. You need to give more well-defined what these bars actually mean, so you're having more consistent outcomes. And also, we did ask, basically, you need to allow the veteran to argue other factors and circumstances, which they do now with 2 of them. They now allow for the compelling circumstances factors that we just talked about before with AWOL. They also now apply to 2 of these regulatory bars we'll discuss. They did remove one of the bars completely, which was the homosexual acts involving aggravating circumstances, because it's very discriminatory. Those are covered by other statutory bars and the regulatory bars anyways. But that was removed, so that's good. They expand when compelling circumstances may be considered to 2 types of the bars. Keep in mind that insanity exceptions continues to apply to these regulatory bars as well. One of the reasons why it looks like the regulatory bars were kept, according to the VA comments that they came up with, where that was the military departments were the one that wanted these regulatory bars to be kept. So even though there's already statutory bars, and we think that's enough, the military departments wanted these to be kept for deterrence purposes. As advocates, we were kind of disagree with that, because the point of VA benefits is very different than the point of other rules that are already out there that exist to help keep anybody who's in active service from, having any kind of misconduct. There's already a whole set of rules for them about that. And, veterans did comment saying, these regulatory bars to benefits were never in their mind, whether they were going to, engage in misconduct or not. It wasn't like something that was going to stop somebody from deter them from engaging in some kind of bad action while they were in the service. That's a ridiculous reason, but the military departments thought otherwise. So that's why we still have these regulatory bars. And what are they? Well, the first two, which have no compelling circumstances exception, that you can't argue those factors, is if you did a discharge in lieu of trial by general court-martial. Again, getting at that they want that statutory bar where the general court-martial exists as a statutory bar. If somebody discharged just to get around a court-martial, they still want that to bar them from benefits. And then mutiny or spying, which I guess wasn't covered by the statutory bar, so they wanted that covered as well. Relatively straightforward, those two. And then here are the more arbitrary ones, which is where a veteran can now argue compelling circumstances. First one is moral turpitude, usually involving conviction of a felony. That's what it says. Very, that could be interpreted in a lot of ways. I mean, moral turpitude in the definition is the definition of it in a dictionary. It's just an act or behavior that gravely violates the sentiment or accepted standard of the community. And you can imagine that changes a lot over time. So it's, that's one of the reasons why as advocates, we don't really like that one. And also willful and persistent misconduct. Especially for this one, the issue was in the prior version, what is persistent was up in the air. And so we were arguing, like, if you're going to make this more specific, which you should, say 3 instances of serious misconduct within 1 year, that would be persistent. That was what we recommended, which, is probably going to be a big ask. But what they came up with, which is here, is they defined persistent a lot more clearly. And it specifically means either 2 instances of minor misconduct within 2 years, or an instance of minor misconduct within 2 years of more serious misconduct, or 2 instances of serious misconduct within 5 years. So they were not nearly as generous as we were asking for. And minor misconduct is defined as misconduct for which the maximum sentence imposable pursuant to the Manual for Courts, Martial United States, would not include a dishonorable discharge or confinement for longer than 1 year. So that they did more specifically define persistent, but it's a very short time frames where a lot of people will fall into this bucket, unfortunately. The nice thing is for both of these is they can argue compelling circumstances now for both of them, because these are very arbitrary. So it's nice that at the very least, the veteran can lay out all of the circumstances surrounding it. There's lots of factors they can argue with both of these, which is good. All right, so when the VA is going to be determining, do these statutory bars, do these regulatory bars apply, that is called a character of discharge determination. That process is a character of discharge determination. It doesn't have been automatically at discharge. It only usually occurs when the veteran initially applies for benefits. And sometimes that means going to their local VA medical center to start getting medical care through the VA. So that it can be initiated by the Veterans Health Administration. The veteran can, even if they're not getting benefits, they can ask for a character of discharge determination to be done as well. Decisions can be appealed, or the veteran can request prior decisions to be reopened. They can request a hearing as part of this determination. The veteran wants to provide context, including personal statements, lay statements, evidence, corroborating mitigation, et cetera. Anything that, especially if it's one of those bars they think might apply that involves where you can argue compelling circumstances. I mean, they want to give them all those factors as well. Keep in mind, because there can be some confusion with this, a character of discharge determination is not the same thing as requesting a discharge upgrade. That's through the Department of Defense, and that would be to upgrade the discharge that's on the discharge paperwork. So the characterization of service on the DD-214, that's a whole separate process. So it can impact VA benefits. And sometimes it makes sense for the veteran to go and upgrade their discharge and then maybe they can request that maybe they already had a character of discharge determination done. They're successful in upgrading their discharge. They can go back and say, hey, I need you guys to reopen this. I've had an upgrade, and that should impact my eligibility for benefits. So it definitely can make it so that somebody who wasn't eligible for benefit support now becomes eligible. It can impact the character of discharge determination, but it is a separate process. So how do these all interact? Does the discharge characterization on the discharge paperwork from the armed forces, how is that read by the VA for VA benefits purposes when they're doing their character of discharge determination? Here's a helpful chart that hopefully makes it a little clear. So on the left, you do have all the different discharge characterizations that the armed forces can give. And then on the right here, you have, is a character of discharge determination going to be needed for VA benefits purposes? And this is from the M21-1 manual. And generally, if you're honorable or general or uncharacterized due to entry-level separation, you're not going to need a character of discharge determination. Technically, there are some exceptions to when that might apply, because you might have been discharged from one of those, but still, if a statutory bar applies, a statutory bar applies. So they still need to, in some instances, have to do review. And then the more gray areas where you're going to have that require a character of discharge determination are for if the discharge characterization is uncharacterized due to void enlistment or drop from the rolls, or if it's an other than honorable discharge, or if it's a bad conduct discharge, but without a general court-martial conviction, because that's one of those statutory bars. If it's for a lesser type of court-martial conviction, it could be more of a gray area. And that's where they're going to require that character of discharge determination, and go through all those. Look at the statutory bars, look at the regulatory bars, look at the compelling circumstances that are, relevant. And then finally, if you had the bad conduct discharge with the general court-martial conviction, which is a statutory bar, or if you're dishonorable discharge, those are the character of discharge determination is still needed. They still do one, but it's likely they're going to be barred from VA benefits. The reason why they might not be is there are insanity exceptions. Keep that in mind. And also keep in mind that if a veteran has 2 periods of service, they may be able to qualify for VA benefits based off of an earlier period of service that was honorable, for example. So those are why they would still need to do a character of discharge determination, and it wouldn't just be an automatic rejection of VA benefits, even in those circumstances. And that gets us to poll question 2. Assuming otherwise eligible, if a client has an other than honorable discharge characterization on their D-214, is he eligible for compensation or pension benefits? Yes, no, or it depends on the character of discharge termination.
I'll give everybody like 10 more seconds to get your answer in. Okay.
Yeah, most of you got it, 89%. It's C. It depends on the character of discharge termination, and I know it might be hard to remember what is an other than honorable discharge in the gray area. It is. It's one of those gray area discharge characterizations where they're going to need to look at the regulatory bars, look at the statutory bars, and again, in that situation, the veteran's going to be looking at trying to maybe ask for a hearing, submit all those factors, the evidence of those factors regarding the compelling circumstances, things like that. And I'll look real fast for questions. None right now, so we'll keep going. All right, so now that a veteran has established that they're a veteran under the VA benefit definition, at least, do they qualify? First, we'll talk about the eligibility requirements for the Service-Connected Disability Compensation Program. Keep in mind, there is something that's similar to the service-connected disability compensation program. We're not going to talk about today. It's called dependency indemnity compensation benefits. And that's a monthly benefit for qualifying surviving spouses, surviving children, or surviving parent based on the record of the veteran, sometimes based off of the veteran passing away too, regarding that had a service-connected condition, but we're not discussing that today. We're just focusing on the veteran's specific benefits that the veteran themselves can receive. So for service-connected compensation, just as a reminder, it's a monthly cash benefit for veterans with a current disease or injury incurred or aggravated during active service. And the disease or injury is not the result of the veteran's willful misconduct. Willful misconduct is defined as an act involving conscious wrongdoing or known prohibited action. It involves deliberate or intentional wrongdoing with knowledge or a wanton and reckless disregard for its possible consequences. So if the reason for the disability is the in-service incident had to do with willful misconduct, they may not qualify for these compensation benefits then. Also keep in mind, this again is not about trying to keep the veteran out of poverty. There's no means testing going on. It's just, can you establish that service connection that you have a current disability that happened because of the result of this in-service incident? So there's no income or net worth requirement. The awards are based on a percentage basis from 0% to 100% in 10% increments. And the rating is based on the severity of the health condition. And the veteran can increase the rating if their condition worsens. Definitely can be one helpful way to find out quickly for a veteran, for them to find out too, are they getting compensation or pension? Because, you know, if they're saying, oh, I get 10% or 20%, 30%, they're probably talking about compensation, because pension benefits doesn't have a rating. It's not that type of a system. It's not about compensation. It's, do they qualify for based on their income and net worth? And keep in mind, the rating system can be very complicated. It's possible to have 2 or more service-connected disabilities that have different percentages, and how they add up to an overall percentage is it's not just like they just add them up. So keep that in mind too. With sometimes veterans are a little confused, like, oh, I got this percentage and this percentage, but my overall percentage is lower. So here are the current compensation rates for 2024. You can see, especially as you get a little bit higher in the ratings, that's pretty significant compensation. And keep in mind, this is just the base compensation rates. These can be increased. If the veteran has dependents and 30% or higher rating, they can get more per month, or they can get what's called special monthly compensation, which we'll go over a little bit later, where they can increase the amount they get, sometimes very, very significantly if they have certain kinds of very debilitating disabilities. So it's kind of been talked about already, but just to lay it out more clearly, what are the elements that have to be satisfied to qualify for compensation benefits? You have to have a current disability. You have to have an in-service incident in the past, and you have to show a nexus, some kind of link or connection between the two. And when it comes to most types of service connection, there's like 5 different theories that we're gonna go over of how you can connect the in-service incident to the current disability. The standard review for that is the benefit of the doubt, or at least as likely as not. Basically meaning, like, if a doctor believes there's a 50-50 chance that the in-service incident is what has caused this current disability, the tie should go to the veteran, essentially. So that's a nice standard to have for them. And almost always, this is going to involve, to satisfy these 3 elements, it's going to involve medical evidence, to have sufficient evidence. And keep in mind, VA often will have a duty to assist in obtaining this evidence, including providing a medical examination to determine whether there's a link there. Because you can imagine, for a lot of veterans who are lower income, low resources, you know, getting a doctor who can do this might be out of reach, or might be very tough to do. So for the first element, when it comes to establishing that they have a current disability, the veteran's almost always going to need a current medical diagnosis, documented with competent medical evidence, meaning from a medical professional. This is how they define competent medical evidence. So if the veteran just says, I think I have this, and here are my symptoms, that's generally not going to be enough. It can also include medical treatises, so keep that in mind, but usually they're going to need something from, it can be their doctor, or as we'll go over, the VA can provide a compensation and pension exam where they determine whether, or at least provide evidence of whether they think there's a link in a current disability and what it is. So that's it's called a C&P exam. It stands for compensation and pension, because that's what they're looking at. As we'll discuss with pension, you also have to have a current disability. So this can be used for that as well. You don't have to establish a nexus with the in-service incident, but they call it a C&P exam for that reason. Also known as a claim exam to establish the diagnoses. You can, the veteran can go to their private medical professional. They don't have to use the VA. If they do that, they'd want to make sure that that private doctor is using the same terminology that the VA wants them to use, kind of, to establish, whether or not they think there's a nexus at what the current disability is it connected to the in-service. So maybe using that as likely as not language. The VA also uses disability benefit questionnaires when they do those C&P exams. So using those same disability benefit questionnaire forms with the private doctor would be helpful, because that's what they're used to, that's what they know. And the veteran's own statements describing symptoms are evidence. It's usually not going to be enough on its own, but it can be important to trigger VA's duty to assist, which we'll go over as well. Trigger their duty to perform this C&P exam and help the veteran gather the evidence needed. The element 2, the in-service incident, also needs to be shown. And that means, the current condition has to be incurred in or aggravated during active military service. One of the different theories for establishing a nexus is that there's certain types of presumptive types of diagnoses where the VA assumes, oh, you have the diagnoses and it was in this time period. We're just going to assume there's a connection. So it might be, even though it didn't incur in service, if it incurred during a qualifying presumptive period, it can also qualify as an in-service incident for the purposes, and we'll go over that element more when we talk about nexus. You do have to be on active duty at the time of the incident, and the incident does not need to be directly related to military duties. It just has happened between the day the veteran entered service and the day that they were discharged. And remember, it cannot be the result of willful misconduct. So if the veteran was driving around recklessly and got into a bad car wreck, that might mean he's not going to get any benefits based off the injuries from that car wreck. So some types of evidence to keep in mind when looking for in-service incident. I mean, the main issue with getting evidence that there was an in-service incident is that it can sometimes be a long time ago. And so trying to get this evidence can be tough. But what they want to be looking for is service treatment records, official military personnel files, other military records that they can request, and they can go to their local Veterans Service Commission to help them get the right forms needed as well if the veteran's doing this on their own. Or medical evidence of the condition arising during a presumptive post-service period, if it's some kind of diagnosis that is presumptively assumed to establish a nexus. Private medical records are great, competent lay evidence, the veteran's own statements, buddy statements of other people he knew who were there, photos, contemporaneous letters, newspapers, agency records, special rules documenting. There are special rules for documenting events in combat for PTSD, but really just trying to get anything to say, yeah, this thing happened. Could be that the veteran got in a fight in their dorm, but they didn't press any charges, so they don't think there's going to be any type of documentation that they got in that fight, and that they think that fight caused a disability that they currently have to this day. But they want to look because they did go and see the doctor, and there's at least a report, even though it doesn't go into details of the fight. It says, here's the injuries that happened. It was, they say they got hit in the face, and then it's showing that they were treated for injuries to the face. So, I mean, again, they want to get anything they can, even if it's a long time ago, to show that this event actually happened. There was an in-service incident that happened that can be related to the current disability. And finally, the veteran has to demonstrate a link or connection between the current condition and the in-service incident. And the 5 theories I've been referencing: you can do a direct service connection, secondary service connection, aggravation, presumptive service connection, or caused by VA healthcare. This last one is kind of an odd duck. It's not quite the same because you don't have to demonstrate an in-service incident. It's more like the VA will allow you to get compensation benefits as if it was in service if down the road you were using the VA for healthcare and they injured you. So for direct service connection, it's a direct causative link between the veteran's current disability and the in-service incident. So for example, veteran was doing parachute jumps and fell badly on a knee, currently has a lot of knee issues. Think it's because of that day that they fell really badly on their knee. So they could get evidence that they saw doctors after the jump that day. A letter from the current doctor saying it's at least as likely as not the current disability is related to the jump that day. Things like that. That's a direct service connection. A secondary service connection is if you have a current disability caused or aggravated by a separate already service-connected condition. So if that veteran already has a service-connected condition for their bad knee, and now their back is hurting because of the way they have to walk with their cane, it's causing back issues. They can try for a secondary service connection for their back issue as well. And there's aggravation, and that's where the veteran had a disability before active service began, but it worsened during service beyond the natural progress of that disability. So if they went in with a bad knee and they were doing jumps and they really, really hurt their knee when they landed, and the way they hurt their knee seems like it made it much worse than it was before, and it would have progressed much more quickly, the deterioration of their knee. I mean, if they can get doctors that can explain this whole process, then yeah, they might qualify for aggravation. And finally, there's the presumptive service connection, where the VA presumes certain disabilities were caused by military service. Examples includes maybe, for tropical diseases, malaria, if they arise within a certain time period, or somebody was exposed to Agent Orange and they got Hodgkin's disease and other types of diagnoses. There's just a whole list of diagnoses that the VA has, and those make this nexus step a lot easier because it's just presumed there's a connection as long as they can show those other factors, the time period they were there, depending on the presumptive connection, when did it arise. So they still have to get those type of records, but it can be a lot easier to show a nexus when it comes to presumptive service connection. And finally, the last one, one that's kind of an odd duck, and that's just if the disability was caused by VA medical care, the veteran can receive compensation as if it was service connected. And in those circumstances, the veteran might wish to consult a Federal Torts Claims Act attorney too to see what all of their options are. So what about the VA's duty to assist we've been talking about? What is it, or like when is it going to get triggered? What does the veteran need to know about that? So the VA does have a duty to obtain records or provide medical examinations or obtain medical opinions. Generally, for the VA to request that C&P exam, if there's not enough evidence, they need evidence of competent lay or medical evidence of the current disability or persistent recurrent symptoms of disability. The evidence that the veteran suffered an incident in service and an indication that the disability may be associated with the in-service incident. So an indication that's very, it's a low standard. They don't have to have a doctor's note right away saying, yes, it is as likely as not that this current diagnosis is the result of this condition that happened in service, this in-service incident. That's what the C&P exam is for, is to actually allow them to get that kind of evidence. And again, that's where it can be helpful if they're working with a Veteran Service Commission, if they're doing this on their own, because they know what those requirements are, and they know how much the veteran should be asking for and what evidence they should be submitting to trigger this C&P exam if they are going to have problems getting it otherwise. So getting this type of evidence otherwise. And then special monthly compensation I mentioned before. This is additional benefits that you can get on top of those base rates that we were talking about. It can be for an anatomical loss or loss of use, such as a loss of use or hand or foot, or impairment of senses. They can get additional award. It also includes an increase if you're permanently housebound due to service-connected disabilities, and that's defined as the veteran being substantially confined to the house, ward, or clinical area, and it looks like it's going to last throughout their lifetime. they can get an increase as well. And for if the veteran needs regular aided attendance from another to perform functions of daily living. And some of these are very, very large increases. I mean, some of them go up to around 10,000 a lot of times for loss of use, but something to keep in mind, especially for veterans who are, housebound, getting aided attendance. Sometimes not something they're thinking about, that they can get an increase into their base benefit. And that brings us to poll question number 3. One of the eligibility requirements for service-connected compensation benefits is that the veteran have low income and low net worth. Is that true or false?
I'll give everybody like 10 more seconds to get your answer in. Okay.
Yeah, 88% false. Correct. That is not what compensation benefits are about. There's no income or net worth. It's just, do they have that service-connected disability? Do they meet all those elements we just discussed? For service-connected compensation, again, they're being compensated for what happened in the past. It says service-connected. That's how the hints say how you just kind of know what type of program they're talking about. There's no net worth or income requirement. I'll check real fast on questions.
You do have a question in the Q&A.
Okay.
And that is, this was back a while ago, so I think this is one of the earlier elements, but does this have to be a physical disability?
Okay, and that was okay. Yeah, so we're getting compensation, the current disability. It does not have to be physical. It can be some other. It can be a mental issue for sure. Yeah, so it does not have to be physical. It encompasses all types of disabilities, and they have different rating. I mean, the rating charts and tables are very crazy, but like they have for mental or physical disabilities, they have different rating charts as to what the severity of that type of diagnosis is, whether it's mental or physical, what kind of rating they'll get. So, and again, it's one of those things for the veteran who's doing this on their own. The Veteran Service Commission is going to be a great resource to help them. Like, they can go and say, oh, I have this issue, but like, it's not a physical issue. Can I qualify? And they can help with that process as well. But yeah, no, it definitely can include cognitive issues as a result of an in-service incident, things like that as well.
Okay. It looks like another question popped up in the chat.
Oh, yeah.
About a blue ID card.
I've never heard that. I'm not sure what that's referencing. A blue ID card at discharge. I am not sure. I'm sorry. I'm not sure. Usually, I mean, for most veterans, they're going to be establishing this compensation benefit after discharge. So, but maybe there's some process where they could get it while they're in service, so that when they're discharged. I'm not. I've just never heard that. I'm sorry.
Okay. That's all the questions I see for now.
All right. And that gets us to the non-service connected disability pension. This is the one that's means tested. This is where your low income, your low net worth matter. It's not service connected. It's all about trying to keep veterans out of poverty. So it's means tested. Keep in mind, there is also a survivor's pension program for qualifying surviving spouse or surviving child. That's similar to this program based on the record of the veteran. We're not discussing that today. Again, just to review our differences that we already went over before, we're getting to non-service connected pension. Non-service connected pension is different in the fact that it's means tested, and also you do have to show that you were a wartime veteran. You also have to show total and permanent disability. but it's a different kind of disability that you're showing. And we'll get into all of that, but those are the main differences. There are 3 types of pension programs. So you might be confused, like, well, which pension program are we talking about today? It's the improved pension program that's the most recent since 1979, and that's the one we're discussing. There is a Section 306, an old law pension program that are older. There might be people who are still getting some awards under these programs, but we're not going to be discussing those. So when it comes to non-service connected pension, we've already covered this. They have to be a veteran who was discharged or released under conditions undesirable, who had active service. But they also have to show that they had wartime service, meeting minimum service requirements. And that's different from the compensation program. And we'll go over what that means. You also have to show permanent total disability, or if you're age 65 plus, that's presumed, and low income and net worth. Your amount of the benefit is going to be calculated based on the veteran's income, which includes the amount of benefit also can increase if they have dependents, if they're housebound, or if they need any attendance. There's special monthly pension, just like there's special monthly compensation, there's special monthly pension for the housebound status and the need for any attendance that can all increase the amount of the benefit as well. It just increases the amount of the benefit, which is already lower generally than compensation in a lot of cases. It's usually not going to increase it as much as it potentially could under the compensation program. And keep in mind, the disability does not need to be service related. So even though you have to show permanent total disability, it's nothing to do with, was it in service? Was there a connection? You don't have to show that kind of stuff. So that first element, the wartime service requirement, which is different from compensation, depending on when they went in, they have different minimum service requirements. If the veteran started active duty prior to September 8th, 1980, they have to have served 90 days on active duty with at least 1 day during a period of war, or 90 consecutive days on active duty with at least 1 day during a period of war, or served an aggregate of 90 days on active duty in 2 or more separate periods of service during more than 1 period of war, or if they were discharged due to service-connected disability while serving during a period of war. Maybe that's, yeah, I would say maybe that blue card has something to do with that, being discharged due to a service-connected disability, but sorry, I don't know off the top of my head. And those periods of war, you can see there are some gaps here. The big gap being from May 7th, 1975 to August 2nd, 1990, there wasn't a period of war. So for veterans with active service during that time, they might not qualify for pension benefits because they just didn't have the active service during a period of war at all. And keep in mind, for the Gulf War, that period of war is still ongoing. So now for veterans who started active duty after September 7th, 1980, they have to have served, the general minimum time in the service requirement is different. You have to have served 24 continuous months, or the full period called active duty with at least 1 day during wartime, or if you have any service-connected condition during the wartime period, you can qualify for, you meet that qualification. These can get kind of weird and nitty gritty depending on if somebody has like some weird circumstances. Again, a good time to talk with the local Veteran Service Commission to see like when, was I on active duty during a period of war? How long was I on active duty? Do I meet this requirement? The second element, they have to show permanent and total disability. What does that mean? Well, for the VA, they do presume for pension purposes that the following are disabled: for age 65 or older, or if you're a patient in a nursing home because of a disability, or if you're receiving SSI or SSDI, then you're presumed disabled. You meet this element. Otherwise, the veteran must prove permanent and total disability. Keep in mind that all disabilities are considered, whether service-connected or not, but it cannot be the result of willful misconduct. If they have to prove total and permanent disability, they have to show either they're unemployable as a result of disability reasonably certain to continue throughout their life, or they're suffering from any disability which is sufficient to render it impossible for the average person to follow a substantially gainful occupation if it's considered throughout their lifetime. That one's very, very similar to the Social Security definition. Or suffering any disease or disorder determined by VA to be of such a nature or extent as to justify a termination that they are totally and permanently disabled. So under one of these three definitions, the veteran can prove it separately if they don't meet those automatic thresholds that we discussed. And then they have to meet the low income and net worth requirements. The income requirement is going to involve countable income, and the veteran's countable income must be below the maximum annual pension rate. That maximum annual pension rate, or the MAPR, varies depending on the number of dependents and whether a special monthly pension applies. So, for example, right now, the current 2024 MAPR amounts, the max the veteran can get under this pension program, it's $16,551 if they're just a single veteran. If they have a dependent, it goes up to $21,674. If they're housebound and single, it's $20,226. If they get 8 attendants for single, it's $27,609. Similar to SSI in that they're only going to pay pension up to that amount, up to the maximum annual pension rate. And that can change, that countable income can change in a lot of ways, and also the MAPR rate can change if there changes in income or dependent status. Medical expenses we'll discuss can be used to deduct from income. If any of that stuff changes for somebody who's on the pension program, they need to report that as soon as possible to the VA to avoid possible overpayment issues. That is one thing I actually do deal with a lot, so I see it all the time. And it's a complicated program, as we're going to discuss. There's lots of factors that can impact whether they qualify. So if any of those factors change, they need to report that as soon as possible to the VA. The veteran might be where the veteran got married, and he reports the marriage to the VA immediately because he remembers he needs to report a marriage. And the VA 10 months later asks him for the income and asset information of the spouse. And it turns out the veteran wasn't eligible that whole 10 months because he didn't realize that he needed to give that information to the VA. They didn't ask for it when he told me he was married, which some of the issues to the VA. Something to keep in mind, like that kind of stuff happens. And that's why anybody who's on the pension program really needs to be on top of reporting to the VA. So the VA is going to reduce the monthly annual pension rate dollar for dollar by the amount of the veteran's countable income to determine what the award is or if they're even eligible for benefits. So what is countable income? It's payments of any kind from any source, unless it's otherwise excluded. Some exclusions, food stamps, income tax refunds, donations from public or private relief, maintenance furnished by a relative, friend, or charitable organization. That usually means like if they're in a facility, like it says a living facility and somebody's paying for the facility for them, that kind of thing doesn't increase their income. Crime victim compensation. And keep in mind, as we'll discuss, the veteran's income does include the dependent spouse. And in some circumstances, children are pretty rare, but it does include the dependent spouse. So what are some deductions to income? Because in addition to income exclusions, you can deduct your income based on certain types of expenses. And that's the expenses of last illness, educational expenses, unreimbursed medical expenses. That's the big one. To qualify as a deduction, as an unreimbursed medical expense, it has to be paid by the veteran or spouse for medical expenses for themselves, children, parents, or other relatives that they have a moral or legal obligation to support. It has to be incurred on behalf of the member or constructive member of the veteran's or spouse's household. And the total amount of the medical expenses you can deduct has to be greater than 5% of whatever the current MAPR rate is, which I'll kind of go over exactly what that means. But essentially, what the VA is saying is they expect that the veteran is going to pay out of pocket for some medical expenses themselves, and then once they reach that threshold, whatever 5% of the current MAPR is, then they're going to be able to deduct that from their countable income for VA pension purposes. Again, maybe the veteran applies for pension and at the time was getting in-home care and they were paying $1,700 a month out of pocket for it. If after 2 years they stop getting that in-home care, the veteran needs to report that as soon as possible to VA, because otherwise 10 years might pass and now the VA saying, oh, there's this giant overpayment. So like, again, something to keep in mind with medical expenses or any of these factors is that the veteran has to stay on top of updating the VA with regards to these factors. What are medical expenses for VA purposes? Generally, it's going to be anything that's medically necessary that improves a disabled individual's functioning, prevents slow or ease an individual's functional decline. It includes assisted living and nursing home expenses. So that's huge. That is where a lot of people are able to qualify for pension that they would otherwise have because it's very expensive. Healthcare provider expenses, in-home care expenses, if it's for assistance with activities of daily living or for instrumental activities of daily living, as long as the attendant provides healthcare or custodial care. Custodial care just means assistance with 2 or more activities of daily living, or if it's prescribed by a doctor, or if the veteran's getting aid attendance or is housebound, then they can get in-home care expenses covered, which can be significant. Health insurance premiums, medications, medical supplies, medical equipment, medical transportation expenses, those can all be used to deduct from countable income. Basically, it can make somebody's countable income 0 potentially, because some of these are very expensive. If somebody already has pretty low income, sometimes they're going to get the max annual pension rate as a result. So just as an example, because it can be kind of confusing when you're just reading what the rules are when it comes to like, what does it mean that they can only deduct above 5% of the current MAPR? So right now, for a single veteran, the current maximum annual pension rate is $16,551, and 5% of that is $827. So that's how much the veteran's going to have to pay out of pocket before they can use any of it to deduct their medical expenses. So if they had, for example, unpaid past medical expense of $40,827, the amount they're going to be able to deduct is $40,000 from their countable income. And then just to kind of give examples of how the countable income calculation works. It's good for the veteran to be able to understand this. If you're helping with VA claims you're accredited and want to help with this process, it can help to like find out, are they getting the right amount? What's going on if there's some kind of issue? They're going to take the household gross annual income and subtract any excluded income that we discussed, subtract any deductible expenses, and that's a countable income. Now, the veteran's income does include the dependent spouse and children in the veteran's custody or to support the veteran is reasonably contributing, but hardship can apply for the child's income. So keep that in mind, it doesn't always qualify for income. So just as an example, you have a single veteran, let's say he has 50,000 household gross annual income, 0 excluded income to subtract, but he has those 40,000 in deductible expenses from the prior example. That would mean he had 10,000 in countable income. And if you want to get the current pension rate, once you know the countable income, you take the current maximum annual pension rate for the veteran, subtract the countable income, divide it by 12, and you get the monthly pension rate. So just from that example, continuing for the same figures, if you have the current MAPR for a single veteran being 16,551, they have countable income of 10,000. The annual pension rate they can get is 6,551. And what's that mean their monthly benefit's going to be? It's going to be $545 a month. Obviously, for this person, one thing they might want to consider is they're paying $40,000. Do they qualify for aid attendance or some other thing? They might qualify for if they're paying that much on medical care. They might want to look into that. And then the last thing to consider if they have low income is, do they have a low net worth? It used to be before 2018, this was very arbitrary. There wasn't a hard limit. Now there is. The current net worth limit, which changes from year to year, is $155,356. It does include the veteran's annual countable income, and that includes also dependent incomes and their assets, which can include the veteran's spouse. It does include the veteran's spouse. The dependent child's net worth is not considered if it exceeds the net worth limit, so keep that in mind. So sometimes a dependent child's assets aren't going to go towards this limit. But generally, it's going to have the assets of the veteran spouse. So even though it seems like a high net worth limit, it's kind of weird because a lot of public benefits that have these resource limits, they they don't count the annual income as part of that. So that is where it's a little bit different.
Hey, Matthew, we're at the 10-minute till the end point, just to give you a heads up.
Okay, perfect. Thanks. The asset definition, it's the fair market value of all property that individual owns, minus any mortgages or other encumbrances. But there are some asset exclusions. The big one being the veteran's primary residence, including a residential lot area of 2 acres, is excluded. Personal effects like appliances and family transportation vehicles are excluded. The veteran usually has to be living in the home, but they're living in a nursing home, a care facility, or the home of another family member for custodial or health care, then it can still be excluded. So if the lot area is larger than 2 acres, you can exclude the additional acreage if it's not marketable. And this is a relatively new rule. They used to have this acreage requirement, so I'm not quite sure how they're interpreting it. You can imagine for some people create a weird issue, or like, how do you value that? How would you say what the marketable value of this? But there is an exclusion in certain cases if that is an issue. And then quickly going over special monthly pension. Increases similar to the special monthly compensation includes the housebound benefit, just like with compensation, if the veteran is substantially confined to the house, ward, or clinical area, and it's going to remain throughout their lifetime, or aid and attendance if they need regular aid and attendance and from another to perform functions of daily living. And that gets us to poll question 4, our last one. In order to qualify for non-service connected pension benefits, the veteran must prove they served in a combat zone. True or false?
I'll give us about 10 more seconds to get our answers in. Okay.
All right, yeah, 90% false. It is false. They just have to serve during a period of war. They don't have to have been in combat zone. They didn't have to have been in combat, just during one of those periods of war that Congress sets out, and that's all they need to show. Those are the basics of the pension eligibility. One thing, since we have a little bit of time, I'll start getting into before we end, is because this is a relatively new rule, is asset transfers. The VA does. Oh, and I'm sorry, before I get into this, I will double check any other questions. In fact, one of these just
Yep, it looks like there's just a couple questions. Someone asked to give an example of moral obligation to support.
That's a good question. I mean, they don't define that really, but like presumably if they have some kind of relationship, I mean, usually it could be a family relationship, then, they could argue that's why their healthcare expenses are being paid for by the veteran. So they don't define it though. So, I mean, I think just as long as they're saying, yeah, this is my, daughter-in-law, but I treat her like my daughter, then that would be a good argument to be made. But it is one of those things where it's like, they don't really define those things. Or what does a constructive household mean? Like it is one of those areas where it's like, well, they could at least make the argument, especially when they're initially submitting the application, like this is why this should count as a deduction. So, and then for the other one, which is there a look back period on assets? Yes, there is. It's 3 years, which I'll try to get into real fast for the end here. I'll just cover, I might not be able to cover all the asset transfers. The asset transfer rules, similar to how long-term Medicaid has asset transfer rules, but it's 3 years, and I'll try to go over the basics real fast. This was the last thing to cover, just in case we had time, kind of a thing. So they've instituted this since October 18, 2018. They didn't have this before. It is a lot more generous than under like something like long-term care Medicaid for people who are familiar with that program, how they do this asset transfers. But if somebody transfers assets for less than fair market value, it can lead to a period of time where the VA is not going to pay pension benefits because they want people getting rid of assets that they could use to pay on themselves, to take care of themselves, just to qualify for the pension program. That's the whole point of the asset transfer rule. The way that they do it is they only look at assets, covered assets that were transferred for less than fair market value. And what does that mean? If it was part of the net worth of the veteran and it was transferred for less than fair market value, and if not transferred, could have caused or partially caused the net worth to exceed the net worth limit, only that portion is going to cause a penalty period. Fair market value is, basically the price at which an asset would change hands with willing buyer and seller. So keep that in mind. The veteran could push back on saying, well, here's an appraisal of the property versus just what the auditor's office says, because it's not always going to be the same thing. The look back period is 36 months, immediately preceding the date on which the VA receives either an original pension claim or a new pension claim. And the penalty period calculation, it's only for the covered asset that exceeded the net worth. And they're going to calculate the penalty period based off of whatever the current maximum annual pension rate is for a veteran in need of aid and attendance, which is currently $2,727 a month. That is the rate at which the penalty will count down. So if somebody transferred about $8,200, and where it's less than fair market value, that would result in about 3 months of no pension, essentially. The beginning date of the penalty period is when the claimant transferred a covered asset or assets during the look back period. It's going to be, the penalty period is going to begin on the first day of the month that follows the date of the transfer. If there's more than one transfer, it's going to be the penalty period beginning on the day of the first day of the month that follows the date of the last transfer. This is a very generous rule because, if somebody transfers $10,000 a year and a half ago, according to this, the beginning date of the penalty period will be a year and a half ago. $10,000, that's about 3-4 months of no pension. But if it begins running a year and a half ago, it might already have ran. So that's where this is potentially this is very generous compared to some of the long-term care Medicaid rules when it comes to this similar kind of thing. They also can do penalty period recalculations where if somebody partially gives back some money, they can reduce the amount of the penalty period. So if somebody gave $10,000 to a child and the child gives $5,000 back and they get this information to the VA on time, it has to be within 60 days that the covered asset was returned, and then 90 days to get evidence, they can actually reduce it. And again, it's so generous that if they give that child it 2 years ago during the 3-year look back, then it might not even matter anyways because the penalty period would have already run. So there are exceptions for transfers as a result of fraud. There's exceptions for transfers to certain types of trusts. This is a quick example so you can understand at least the amounts that how this works with the amounts in terms of what can qualify for the penalty period. Let's say you have somebody where the net worth limit is $123,600 and the claimant has $115,900 in assets, but they transferred $30,000 by giving it to a friend. So how much of that $30,000 is actually going to count towards the penalty period? It's only going to be the amount that put them over the $123,600. So it's only going to be $22,300 that they're going to count towards penalty period. That's about 8 months of no pension. But they transferred this a year and a half ago, then they wouldn't have any, the penalty period would have already run, which is, again, is where this is very generous. So the last example, just really quickly, is they, basically if somebody gave $30,000 away and they were already over the net worth limit, they weren't qualified yet, it still can trigger that look back period. It's still, the look back period is triggered by the application, and it would still trigger a penalty period as well for the full $30,000 because it was over the net worth limit. And very, very quickly, there is a new law. This is just related to overpayment issues that does make it much more friendly to the veteran when it comes to if they report information to the VA and the VA didn't take action for a while and it caused a debt, which I've seen happen all the time. As of December of 2022, there is a new law where the veteran used to just have to show sole administrative error in those circumstances, which is really hard to prove. Now it's as long as it was attributable to the failure of an employee or official to process information provided within applicable timeliness standards. Those timeliness standards have not been established yet, so we don't know what those are, but it's a new tool for people who have overpayments to at least argue like, hey, I submitted the information, you guys got it way back then. You let a year pass, now there's a giant overpayment. So if there's any other questions that I wasn't able to get to, you can always email me. And I think that was all the questions I see right now.
Sorry, I was muted. Yeah, that's all the questions I see right now. But thank you, perfect timing, great job, and lots of excellent information. See some thank yous popping up. So again, we have contact information right here for Matthew. So if you have additional questions, reach out to him. And thank you everyone for joining us today. And we will hopefully see you back next Friday for our session on reverse mortgages.
All right, thanks so much. Have a nice weekend, guys.